Hello everyone. Today we have a topic called Territorial Jurisdiction under the Indian Penal Code 1860. So before going into the detailed discussion that what we call the Territorial Jurisdiction, we must know that what the preamble of the Indian Penal Code says. As per preamble of the Indian Penal Code, it says whereas it is expedient to provide a general penal code for India, it is enacted as follows. Now, the question is what we call a penal code which is general in nature. What does it mean? That means this is the code where all the general crimes has been defined and therefore it contains every type of crime, even a crime like domestic violence, a crime like as defined under the TADA, MACOCA, all are qualified to be incorporated under the Indian Penal Code. But due to some reason, it has not been incorporated in the Indian Penal Code. Rather, a special law has been made for the purpose. Since it is called a penal code means a code, a law under which the penalty has been defined, the punishment has been given, and that is why it is called a penal code. Since it is general penal code, so all the law, whatever the law were available at that point of time, all were included in the Indian Penal Code. Question is what we call the preamble. Since the preamble states the reason and objectives which the legislature intended to achieve. What does it mean? The legislature intended to punish the individual. The legislature intended to eradicate the crime from the society, and therefore this was an objective of the Indian Penal Code. In other words, as per Justice Halsbury and later on as per Justice Krishna Iyer, it is a key to open the minds of the makers of the legislation. What does it mean? What the legislature intended at that point of time while making the law, and therefore their intention is to make a general law for entire country with respect to crime in the country. It is an integral part of the law. Earlier, you might have studied in Indian Constitution that where in case of Berubari, in the Berubari case, it was decided by the Supreme Court of India that preamble is not the part of the Indian Constitution. Later on, in case of Keswanand Bharati case, the Supreme Court of India declared that the preamble is the part of the Indian Constitution. So, by virtue of that interpretation of the Constitution of India, we can say that the preamble of the Indian Penal Code is a part of the Indian Penal Code and it can be taken into consideration while interpreting the Indian Penal Code. If there is any ambiguity arises with respect to any provision, then preamble can be taken into consideration for interpreting that law or that provision, since the preamble is the part of the Indian Penal Code. It is the reflection of idea enshrined in the Indian Penal Code. So whatever the ideas were there at that point of time, that all are enshrined in the preamble of any statute and so as the Indian Penal Code. It may look into for the clearing the ambiguity. If there is any doubt, if there is any ambiguity, then the preamble can be referred. Now, one question may arise in your mind that if the provision is very much clear, its meaning is very much clear, then whether again we should refer to the preamble? No, certainly not. If the meaning is clear, if there is no ambiguity, then in such a situation, there is no need to refer to the preamble of any statute or any text. Again, the question may come in your mind that why it is called code and why not act. What is the difference between the code and act? Basically, code includes all types of law on a particular subject matter. Let us take an example of the Indian Penal Code itself. At that point of time, whatever the crimes were available, all were incorporated in the Indian Penal Code. For example, crime against women, crime against property, crime against army, crime against military, crime against crime against political scenario, crime against public tranquility, crime against sexual offenses, crime against the human body, so whatever the crimes were available at that point of time, all were included in the Indian Penal Code. And even the in case of domestic violence, crime in case of terrorism, so that all are also qualified to be included in the Indian Penal Code. Since we cannot include each and every crime in the Indian Penal Code. The reason is it would become a very bulky document and nobody going to refer it. For example, the Indian Companies Act 1956. After amendment, it became a very bulky document, and later on in the year 2013, the Parliament came with the new law called the Companies Act 2013. So, therefore, to make it relevant to for continuing its relevance, the parliament is not including the other crimes into the Indian Penal Code, although those crimes which are necessary to be incorporated are being incorporated. For example, crime against women, that all are being incorporated under the Indian Penal Code. For example, there is an amendment took place in the year 2013 after the Nirbhaya rape case, and therefore that was incorporated under the Indian Penal Code, CIPC, and also Indian Evidence Act. Come to the point, extent and the operation. And that extent and operation shall be read with section 18 of the Indian Penal Code. Under section 18, the term India has been defined, and that says India means the territory of India excluding the state of Jammu and Kashmir. But now, as per the Jammu and Kashmir Reorganization Act 2019, now the Indian Penal Code is extended to the state of Jammu and Kashmir. Earlier, there was the Ranbeen Penal Code for the Jammu and Kashmir, but now Indian Penal Code has been extended to Jammu and Kashmir by virtue of Jammu and Kashmir Reorganization Act 2019. So the Indian Penal Code is not only extended to the land territory of India, rather some water. For example, see this area that is also incorporated in the territory or in the definition of the territory of India, because the India is having sovereignty over this portion of sea, or the some portion of sea. We will discuss later that up to what extent the Indian territory can be defined, or India is having sovereignty over the sea up to what extent. Now come to a very important aspect of the territorial jurisdiction, that is called jurisdiction as defined under section 2 of the Indian Penal Code. As per section 2, punishment of offences committed within India, that is defined. What it says, every person shall be liable to punishment under this code and not otherwise for every act or omission, contrary to provisions thereof, of which he shall be guilty within India. If we will interpret this provision, then we will find that this provision is defining that about the punishment of offences which is committed within the territory of India. If the offence is committed outside of the territory of India, then by virtue of section 2, the person would not be liable. So, first of all, the term territory has to be defined, that what we call India. As per section 18, we have studied that the entire territory, including the Jammu and Kashmir, by Jammu and Kashmir Reorganization Act 2019, now understood that what is territory of India. But apart from this mainland, we have some other territory that we will discuss later. So whatever the offence is committed within the territory of India, all are liable to be prosecuted or are liable to be punished within the territory of India. So what it says, every person shall be liable to punishment. So here, what does it mean? Every person. Here, the every person means the natural person and not the juristic person. So here, the every person means the natural person, the man and woman shall be liable to the punishment and not any company or corporation. For them, there are some different laws under which they shall be punished. So every person shall be liable to be punishment under this code and not otherwise. So every person if who is committing a crime defined under the Indian Penal Code, then he shall be liable to punishment and not otherwise. What does it mean? He shall not be punished otherwise, rather he shall be punished under the Indian Penal Code for every act and omission. So he shall be punished not only for his act, rather for his omission too. What does it mean? If I already told you that what we called act and what we called omission. In case of act, suppose someone is someone is giving the poison to other. In such a situation, it is an act. And in case of omission, what happened? The someone is not providing food, then that is an act of omission. So for every act as well as for every omission, for which we must study section 32 and section 33 of the Indian Penal Code, that what we call the act and omission contrary to the provisions thereof. So his act, his omission is basically contrary, it is against the provision of the Indian Penal Code, of which he shall be guilty within the India. So he shall be guilty because it is contrary to the provisions and it was an act or omission, and that act or omission was a guilty act or guilty omission, and it was a crime defined under the Indian Penal Code, and therefore every person means here the natural person and not the juristic person, and he shall be liable for such offense. Now the question is, what is the literal meaning of jurisdiction? What is the literal meaning of the jurisdiction? Here, juris means the law, and dicto means to dictate, to speak, and therefore it is made up of by the two words juris plus dicto, and that is called jurisdiction. Juris plus dicto is equal to jurisdiction, and literally it means I speak by the law, or in other words we can say I speak by the authority of law. What does it mean? If the judge is not having an authority to speak, then if he is speaking, then that is ultra vires, and that punishment would not have any operation, that punishment would not have any sanctity. For example, a judge is having power to punish for the 3 years of imprisonment, but he is punishing with 7 years of imprisonment. In such a situation, that punishment would not have any weightage because he is not speaking by the authority of law. He don't have jurisdiction to pronounce the judgment. Similarly, if the crime is committed outside of territory of India, let us take an example of America. The crime has been committed in America, then the Indian courts will not have jurisdiction because even the judge is punishing that individual, still the judge is not having authority of law, judge is not speaking by the authority of law, and therefore that punishment would not have any effect over the accused or the criminal. So jurisdiction means there must be an authority of law to speak, there must be an authority of law to dictate, there must be an authority of law to deliver the judgment. If that authority is lacking, then there cannot be a punishment. Now come to a very important aspect of jurisdiction, that what we call the jurisdiction is, and we have understood that jurisdiction means someone if is speaking by the authority of law, then it is called a jurisdiction. The criminal courts exercise jurisdiction either because of crime committed within the territory of India. Number one, the criminal code exercising the jurisdiction either because the crime committed within the territory of India, either by Indian national or by the foreigner, and that is called the intra-territorial jurisdiction. What does it mean? If a crime is committed within the territory of Delhi, then the Delhi courts would have jurisdiction. The Delhi lower court, Chief Judicial Magistrate Court or the High Court, Sessions Court, or even the Supreme Court of India would have jurisdiction if the crime is committed by the Indian national or by the foreign national, and that is called the intra-territorial jurisdiction. But suppose if the crime is committed outside of territory of India by any Indian national, then again Indian courts would have the jurisdiction, and that is called the extraterritorial jurisdiction, because the crime was committed although outside of territory of India, but it was committed by the Indian national, and therefore the Indian courts would have jurisdiction. Let us see the point that what are the kinds of jurisdiction. There are various kinds of jurisdiction, but here, for sake of our understanding, we would take only three kinds of jurisdiction. Number one, the personal jurisdiction, that is also called a subject matter jurisdiction. Number two, the territorial jurisdiction, and number three, the pecuniary jurisdiction. The subject matter jurisdiction or the territorial jurisdiction means the court's power to exercise jurisdiction over every person just because the cause of action arises. What does it mean? If any Indian national or the foreign national committing any offence within the territory of India or within the jurisdiction of the court, within the territorial jurisdiction of the court, then the cause of action arises in such territory, and therefore the criminal courts would have jurisdiction. For example, the murder is committed within the territory of Lucknow. In such a situation, the Lucknow court would have jurisdiction over the issue because the cause of action arises within the territory of Lucknow, either by Indian national, the crime is committed either by Indian national or by the foreign national. Similarly, the territorial jurisdiction. Territorial jurisdiction is basically intra-territorial jurisdiction or the extraterritorial jurisdiction. As we have understood that if the cause of action arises within the territory of a state or within the territory of the district, then such sessions court would have jurisdiction. If the cause of action arises outside of the territory of India, but it was done by the Indian national, then again the Indian courts would have jurisdiction. In case of subject matter jurisdiction, it is with respect to crime, the nature of crime. For example, if it is a domestic violence, if it is a crime against women, then in such a situation, the women court, the family court would have jurisdiction. Similarly, if it is murder, then the sessions court would have jurisdiction. So it is because of cause of action, it is because of nature of action, the cause of action arises, then it is called personal jurisdiction or the subject matter jurisdiction. In case of territorial jurisdiction, we define the jurisdiction as per the territory, as per the boundary of the courts. Similarly, the pecuniary jurisdiction. In case of pecuniary jurisdiction, what happens? The court is having power to impose the penalty. For example, judicial magistrate first class is having power to impose 10,000 rupees as fine, and the judicial magistrate second class is having power to impose 5,000 rupees as fine, and that fine, that limitation of fine is varies from state to state. Some states are having some higher pecuniary jurisdiction, and some states are having some lower pecuniary jurisdiction to impose penalty. Now, come to the point that territorial jurisdiction, that is our main concern. Here, the territorial jurisdiction are divided into two parts: the intra-territorial jurisdiction and the extraterritorial jurisdiction. We would continue our discussion with respect to intra-territorial jurisdiction and the extraterritorial jurisdiction in our next lecture. For intra-territorial jurisdiction, you must study Section 2 of the Indian Penal Code, and for the extraterritorial jurisdiction, you must study Section 3, Section 4, and Article 245, Class 2 of the Indian Constitution, where you will study, where you will get the glimpse that what we call the extraterritorial jurisdiction, that we will study in our next lecture. Now, come to a very important aspect of intra-territorial jurisdiction. Uh, Criminal jurisprudence exercises the jurisdiction or the criminal jurisdiction, and that depends on the locality of the offense committed. It's a very important term, the locality of the offense committed and not upon the nationality or the locality of the offender. What does it mean? If the crime is committed within the territory of India, then the Indian criminal courts would have jurisdiction, irrespective of the fact whether it was an Indian national or a foreign national. It doesn't matter. Even a foreigner committing a crime within the territory of India, as defined under the Indian Penal Code, then the Indian courts would have jurisdiction. Now, the question is what we call territory. As we have already studied section 18 of the Indian Penal Code, that what we call Indian territory. So, apart from section 18, we have some other area that is also called the Indian territory. For example, the mainland, that is section 18 of the Indian Penal Code, and read with Jammu and Kashmir Reorganization Act 2019. Now, the internal waters. If any crime is committed in any lake, if any crime is committed in a river or any canal, then in such a situation, the Indian courts would have the jurisdiction in which territory the crime is committed. And similarly, some portion of sea, that is also called a maritime jurisdiction. In such a situation, the Indian courts would have jurisdiction. Even in the some portion of sea, if the crime is committed, then the Indian courts would have jurisdiction. Now the question is, what is the extent of some portion? What is the extent of subportion? Up to what extent we would say that the Indian courts would have jurisdiction up to this extent, for example, up to this kilometer, up to this mile, or up to this nautical mile. In sea area, we are measuring the length of the sea with the nautical mile and not with the mile or the kilometer. So Indian courts would have a territorial sea or the exclusive jurisdiction up to 12 nautical miles. What does it mean? Not only the mainland, the baseland is not only the territory, rather up to 12 nautical mile is also considered to be the exclusive part of the country or the India. For example, from the appropriate baseline to 12 nautical mile, it is the territorial sea of India, and India can do anything anything up to 12 nautical mile. But beyond 12 nautical mile, there is no exclusive jurisdiction. From 12 nautical mile to 200 nautical mile, there is a zone called exclusive economic zone, where the Indian courts or where the India would have a limited jurisdiction, where the India would have a limited jurisdiction. But suppose if the crime is committed up to 24 nautical mile, then the Indian courts would have jurisdiction. So what we understood, up to 12 nautical mile, the Indian courts would have the India would have an exclusive jurisdiction, and that is considered to be its own territory. That is considered to be its own territory, like mainland from the appropriate baseline. And if the crime is committed up to 24 nautical mile, if the crime is committed from the appropriate baseline to 24 nautical mile, then that is called contiguous zone. In such a situation, the Indian courts would have jurisdiction. After 24 nautical mile, there is no jurisdiction of the Indian Penal Code, and that is called exclusive economic zone. That is for the economic purposes. That zone is for the economic purposes, for the ship, for the commercial ship. No territory would claim over the over such area. Rather it would be called as exclusive economic zone, and any country ship can enter into that zone, but any country ship cannot enter into the territorial sea, that where the India would have exclusive jurisdiction. But if any ship is entering into up to 24 nautical mile, and if on that ship if any crime is committed, then the Indian courts would have jurisdiction. Now come to the point that what are other things that are also incorporated within the definition of the territory in case of extraterritorial jurisdiction. Here the territory also includes the ship registered within the territory of India, aircraft whether armed or unarmed, registered within the territory of India, private ship in the high sea, foreign private ship within its territory. So what does it mean? How we would say that it is the territory of India? Its ship, if a ship which is registered within the territory of India, and even if it is in the coastal area of America, it is in the high sea, still it is considered to be the territory of India because it goes with the flag of India. Because a ship goes with the flag of India, and therefore that the area of the ship is considered to be Indian territory. If any crime is committed on that ship, then it is considered to be a crime has been committed within the territory of India, and therefore the person, the accused, whether Indian national or foreign national, shall be punished as per Indian Penal Code. Similarly, the aircraft. If even if the aircraft is in US, aircraft is in UK, still if a crime is committed over the aircraft, whether armed aircraft or unarmed aircraft, still the person shall be punished for the offences. Similarly, a private ship in the high sea, even if it is a private ship, not a government ship, still the ship goes with the Indian flag, and therefore even if it is in high sea and if the crime is committed on that ship, still the person shall be punished and prosecuted within the territory of India. And the high sea, what is the definition of high sea? After 200 nautical mile, the sea area is called, the ocean area is called the high sea, where no country would have jurisdiction, where no country shall have jurisdiction, and therefore it is called a high sea. And if any crime is committed on that in that high sea, then which court would have jurisdiction? The court to which the ship belongs would have the jurisdiction. Similarly, a foreign ship within its territory. If a foreign ship comes within 24 nautical mile or within 12 nautical mile, if any crime is committed on that ship, then the Indian court would have jurisdiction. Now, come to the point, every person. What does it mean? The term every person defined under the Indian Penal Code, but here, as per section 2, within the definition of section 2, what we call every person. So here, section 2 makes every person liable irrespective of his nationality, irrespective of his allegiance, his rank, his status, his caste, his color, his creed. So every person shall be liable to be prosecuted for any offense committed within the territory of India. And even it includes non-citizen also. Non-citizen means the foreigner shall also be liable to be prosecuted within the territory of India, but does not include a juristic person. That's very important line. But it does not include a juristic person. That's very important line. So what does it mean? A company or corporation shall not be prosecuted within the territory of India, because a company cannot commit the offense of theft, a company cannot commit the offense of robbery, a company cannot commit the offense of dacoity, a company cannot commit the offense of rape. Rather, the person who is holding the company, rather the person who is managing the company shall commit these type of offenses, and therefore the person behind the company shall be prosecuted for the offense. So whatever the crime is committed, it is being committed by the natural person, and therefore the natural person shall be liable to be prosecuted under the Indian Penal Code and not the juristic person. Now come to a very important aspect of the territorial jurisdiction, that is corporal presence is not required. Corporal presence is not a mandatory requirement for holding the accused liable, provided that all the ingredients of the offense occurred within the territory of India and all the ingredients of offense has been satisfied with. What does it mean? Uh, Let us take a case called Mubarak Ali Ahmad versus the state of Bombay. It was decided in the year 1957 by the Supreme Court of India. What happened in this case? There was a Pakistani citizen while staying in the Karachi. He made a false representation to the complainant at Bombay through the letter, through the telephone calls, and through the telegram. This was his means of communication, and he represented to the complainant at Bombay. He induced the complainant to give rupees 5 lakh, over rupees 5 lakh to the agent of the accused at Bombay so that the rice may be shipped from Karachi to Bombay. But basically, the rice was never shipped. It was never supplied by the accused to the complainant. Finally, the complainant complained and the accused was arrested from the United Kingdom through the extradition process. Then he was tried and prosecuted and later on convicted under Section 420 of the Indian Penal Code. He made a defense that Indian courts would have no jurisdiction over his issue. Over this issue, the Supreme Court upheld the conviction of the accused and held that offence was committed by the accused at Bombay. The I repeat the line that the Supreme Court upheld the judgment and the Supreme Court held the offence was committed within the territory of India. It was committed at Bombay, though he was not physically present at Bombay. He was not physically present at Bombay. Uh, Still, he shall be prosecuted and he shall be punished. And therefore, ultimately, the Supreme Court of India punished him for the offence committed at Bombay, although he was at Karachi at that point of time. Now, come to a very important aspect of the criminal jurisdiction of the Indian courts, that is exemption from the criminal prosecution. However, in IPC, there is no exemption from the prosecution, but some persons are having immunity from the prosecution by virtue of the Constitution of India or agreements between two sovereign nations. These persons are entitled to not to be prosecuted by the Indian criminal courts. For example, the foreign sovereign. The foreign sovereign is not subject to the law of the another sovereign country. For example, the Indian Prime Minister, the Indian uh, President is not subject to law made by the US, is not subject to law made by the Pakistan, Afghanistan. Rather, they are subject to law made by the Indian Parliament. Similarly, high dignitaries within the territory of India, for example, the President, the Vice President, and the governors of the state are not subject to criminal prosecution by virtue of Article 105, Article 194, and Article 361 of the Indian Constitution, which exempts from the criminal prosecution to these dignitaries, that is, President, Vice President, and the Governor. They are not liable to be prosecuted within their tenure. After their tenure, after the completion of their tenure, they can be prosecuted for the criminal offense. Similarly, the ambassadors, diplomats, consul, UN representative, a high commissioner, they are exempted from the criminal prosecution because they are having a diplomatic immunity provided by the international agreements, or we can say the United Nations. Again, the alien army and the foreign army are not liable to be prosecuted under the Indian Penal Code. Rather, they are liable to be prosecuted under the martial law or the army law. Hope you might have understood that what we call the territorial jurisdiction and the intra-territorial jurisdiction. We will study in our next lecture that what we call the extraterritorial jurisdiction. Thank you. Thank you very much.